We good? All right, thank you. All right, I'm going to call the Justice Committee to order. The first item on the agenda is roll call. Julie?
Member Martin.
Here.
Member Wendt.
Here.
Member Schaefer.
Here.
Member Chung.
Present.
Member Smith.
Here.
Member Beer.
Here.
And Chairman Erickson.
Here. Thank you, Julie. The next item on the agenda is approval of the minutes. The first item we have is the approval of the January 14, 2021 special meeting minutes and the February 2nd, 2021 regular meeting. I presume I can take those together. I don't have to do them separately, do I?
Yes, sir, you can take those together.
Okay, I'm going to take those together unless anybody has an objection. Can I have a motion to approve? A motion by member Wendt and a second by member Chung. Does anybody have any additions or corrections to those meeting minutes? All right, seeing none, let's go ahead and
Member Wendt.
All right. Yes. Yes.
Member Schaefer.
Yes.
Yes. Member Chung.
Yes.
Yes. Member Smith.
Yes. Yes.
Member Beer.
Yes.
Yes. Member Martin.
Yes. Yes.
Chairman Erickson.
I'm not going to do it today.
Is there an echo or something? Is that what we're having problems with? So like when I say yes, it goes twice or something or what?
No, just
Okay, that's not me. I'm not hearing it twice.
Okay. Are we good? Am I
You're good.
Am I good? All right. Next item on the agenda is item number 3, appearance by members of the public. County Administrator Rodriguez.
Thank you, Chairman Erickson and membership. I just wanted to set the table that we have a number of public comments to get through this evening. We have 2 that are in person, and I'm going to escort each party into room 404 here for you to hear their comment. And then after that, Ms. Morlock is going to read the submitted comments that the requesters wanted read by us, and I will be timing her. Just a friendly reminder that the total time of read comments for committee meetings is 30 minutes. And for the public and for membership to know, once we hit that 30-minute mark, I will be requesting Ms. Morlock to stop. If she does not get through all of the comments, all of them still will be made part of the minutes, even if they were not read. So if you'll excuse me for one moment, I'm going to go get the first public commenter and we will go from there. Just excuse me for 1 second.
okay. I appreciate it.
Here you go.
Hopefully, time goes well, it'll be under time. Hello, my name is Robert Garcia. I'm a resident of McLean County, and I rise today in opposition to agenda item 5.A.1, a resolution that signals opposing changes to the Illinois Qualified Immunity Act. According to the Pew Research Center, a nonpartisan think tank, 66% of Americans specifically support ending qualified immunity, and only 32% of Americans actually want to keep it. Now, mind you, most Americans didn't even know what this legal doctrine was just 5 or 10 years ago. But today, more and more Americans have become informed and are actually aware of this legal doctrine. And it is no coincidence that as Americans become more educated about qualified immunity, they also overwhelmingly oppose qualified immunity. In fact, according to the Cato Institute, an overwhelming 80% of Americans also want officers to be held accountable when they break the law, even if they didn't know they were breaking the law. If you or I or any member of the public breaks the law, we can't say that our ignorance of the law is a valid defense. And it shouldn't be a valid defense for those that we pay to enforce the law. Essentially, in all of these statistics, Americans are saying the same thing. No one is above the law. If you or I or a cop breaks the law, we should all be held to account. That's what the American people believe, with 8 in 10 Americans sharing this same simple value. No one should be above the law, especially those who proclaim to enforce it. Now, since the Republican members of this committee chose to make this a partisan issue today, let's look at the partisan numbers. We already know that 90% of Democrats oppose allowing bad cops to use ignorance of the law as a defense for breaking the law. We also know that 80% of independents also oppose this defense by bad cops. So let's look at just the Republican numbers. These are your constituents. 60% of just Republicans also believe that if a cop breaks the law, they should be held accountable just like you or I, even if the cop claims ignorance of the law. Again, the vast majority of your own voters are telling you they do not support letting cops break our laws and get away with it. We all believe that no one should be above the law, regardless of party affiliation. So I'm confused as to who you think you're representing when your own voters are telling you loud and clear, we think everyone should respect our laws. And again, this value is consistently upheld. No one is above the law. It is that simple. There's plenty of case law around this doctrine. So what exactly does qualified immunity mean? How is it actually applied by judges in the courts where our laws are enforced? Qualified immunity specifically protects cops who violate the constitutional rights of American citizens. It applies specifically to cases where cops are found guilty of misconduct in order to dismiss their cases even when they are found guilty. It's used only to protect the bad cops. So when you say you support qualified immunity, you are not supporting law enforcement. You are not supporting the good cops. You are specifically supporting the bad cops who break our laws, violate our constitutional rights, and are found guilty of misconduct. That's who you're supporting. You support bad cops. And let us be clear, that is not the same as supporting law enforcement. When your own voters are telling you that we have a moral obligation to respect our laws and ensure that no one is above the law, this is your cue that you are on the wrong side of history. Your stubborn refusal to allow us to do better is exactly how your service will be remembered. Times are changing. Americans want police reform. We see it as a moral duty and obligation to protect our neighbors, to protect people of color, to end systemic racism, and yes, to end the shielding of bad cops by eventually doing away with qualified immunity. The saddest part about all of this today is that this is nothing more than political theater. This resolution is non-binding and meaningless. It embodies the worst of politics. It's one-sided, it's abusive, it's partisan, it promotes misinformation and fear-mongering, and worst of all, it shows you have failed in your duties to represent the citizens of McLean County. I urge you to toss this resolution in the trash and start listening to the people of McLean County. Thank you.
The Bloomington Normal branch of the National Association for the Advancement of Colored People, NAACP, Ms. Camila Rodriguez, and the McLean County Board, the NAACP Bloomington Normal Executive Committee. This is regarding the resolution regarding House Bill 3653. As the world's oldest, largest, and most respected civil rights organization, the NAACP supports and endorses the tenets associated with House Bill 3653. Prior to the recent onslaught of police brutality against people of color, the Illinois NAACP was on the forefront of policing issues, as we have proudly affirmed the following 10 shared principles. As I share these principles, please be aware that our community law enforcement, Bloomington Police Department, Normal Police Department, and Illinois State University Police Department share and affirm these beliefs. The Illinois State Conference of the NAACP affirms the following principles regarding the relationship between law enforcement and the community and the people they serve in Illinois. Number one, we value the life of every person and consider life to be the highest value. Number two, all persons should be treated with dignity and respect. This is another fundamental value. Number three, we reject discrimination towards any person that is based on race, ethnicity, religion, color, nationality, immigration status, sexual orientation, gender, disability, or familiarity status. Number four, we endorse the 6 pillars in the report of the President's Task Force of 21st Century Policing. The first pillar is to build and rebuild trust through procedural justice, transparency, accountability, and honest recognition of the past and present obstacles. We endorse the 4 pillars of procedural justice, which are fairness, which gives an opportunity for citizens to have a voice, and to police to believe that they are being heard, transparency, and impartiality. Now I'm moving on to number 6 by Dr. Carla Campbell Jackson, our first vice president of the NAACP.
Thank you, Madam President. Number 6, we endorse the values inherent in community policing, which includes community partnerships involving law enforcement agencies. Number 7, we believe developing strong, ongoing relationships between law enforcement and communities of color leads to and diminishes elements associated with racism and discrimination. Law enforcement and community leaders have a mutual responsibility to encourage all citizens to gain a better understanding and knowledge of the law to assist them in their interactions with law enforcement. Number 9, we support diversity in police departments and in the law enforcement profession. Finally, number 10, we believe that de-escalating training should be required to ensure the safety of community members and officers. As such, please know that the Bloomington Normal branch of the NAACP respects the work of enforcement agencies when conducted decently and in order without regard to race or socioeconomic class. Many members of the NAACP have family members who diligently serve as members of law enforcement. However, racially motivating policing is discriminatory, deplorable, and intolerable. The Bloomington Normal branch of the NAACP is demanding the McLean County Board cease and desist with misinformation regarding House Bill 3653 and any other factors associated therein. This divisiveness does not propel our community forward and does not put us on the proper trajectory. Instead, we must work together to support House Bill 3653, immunity issues, and to embrace the aforementioned shared principles as offered by President Linda Foster. The collaborative efforts will assist with replacing mistrust with mutual trust as we all work towards a more perfect union. Thank you.
Ms. Morlock, it is time for you now to read the comments that were submitted via email. Thank you.
Thank you. The first comment that I have was submitted by Zachary Gittrick. Can everyone hear me? I am speaking to you on behalf of the Solidarity Research Working Group. We heard rumblings from below that this body would be bringing up the issue of qualified immunity for officers. The recently signed law, HB 3653, does not get rid of qualified immunity, but does create some kind of commission to study the issue and bring forth an opinion. I guess some fear it is inevitable that qualified immunity will be abolished. Now, some individuals who are far more perfidious than I will allege that abolishing qualified immunity will have a chilling effect on police officers and limit their ability and/or willingness to respond to critical incidents without hesitation. These are split-second decisions after all. Mistakes happen, right? Why should police have to worry about frivolous incidents? The Supreme Court's constitutional standards make ample allowance for officers to make reasonable mistakes. When assessing the constitutionality of a stop, the Supreme Court has said that officers must act reasonably, but, quote, to be reasonable is not to be perfect, and so the Fourth Amendment allows for some mistakes on the part of government officials, giving them fair leeway for enforcing the law and the community's protection, end quote. For that reason, officers can constitutionally stop or frisk someone when they have reasonable suspicion, and that low bar is met so long as there is a moderate chance that the officer's suspicion is correct. An officer can get a warrant or arrest someone when they have probable cause, which requires only a fair probability that they are right. In short, officers have plenty of leeway to make mistakes without violating the Constitution. For example, courts have held that officers act constitutionally when, 1, officers arrest the wrong person so long as their mistake was reasonable. 2, officers execute a search warrant on the wrong apartment so long as the apartment numbers were similar. 3, officers pull someone over for having an air freshener attached to their rearview mirror or not having a front license plate, neither of which was illegal, so long as the officer had a reasonable but mistaken understanding of the law. Qualified immunity does not protect officers who make reasonable mistakes because reasonable mistakes do not violate the Fourth Amendment in the first place. Instead, qualified immunity shields government officials from liability when they have acted unreasonably, taking into account the deference that the Supreme Court has built into that term, so long as there isn't another court decision holding virtually identical facts to be unconstitutional. Insisting that officers are so afraid of the consequences for their unreasonable actions that they will refuse to do their jobs demeans officers instead of treating them as the professionals that individuals more perfidious than I insist officers are. Finally, I will point out McLean County already has indemnification and duty to defend clauses in their union contract. Regardless of qualified immunity, those legal mechanisms still exist to protect officers. If anything, we believe you should be taking a look more closely at those than some symbolic gesture about qualified immunity. There are legitimate reasons to indemnify and defend officers, but is blanket indemnification truly the right way to go? If something similar to George Floyd, Breonna Taylor, or Elijah McLean occurred here, does the county really want to pay out taxpayer dollars to acts that are unreasonably unconstitutional? Perhaps a mechanism whereby in certain particularly egregious instances, the county could opt out. That's all we have to say on the issue, Zachary Gittrick. The next comment was submitted by Michael Swanson. My name is Michael Swanson, and I am a constituent of yours in District 7. Recently, I have learned that the Justice Committee of the Board will be considering a resolution on whether or not to support the continuation of qualified immunity in our community police departments, which was completely left out of the recent justice bill signed by Governor Pritzker. This email is being sent to inform you that I would like for you to not support qualified immunity, as it creates a dangerous culture that does not protect our communities and is abused to the point that it fails to keep our police departments accountable to public safety. Please vote against any motion to support the continuation of this practice. Thank you, Michael Swanson. Next is from Jill Blair. I would like to express my displeasure that the County Board Justice Committee is going to consider a resolution to oppose changes in qualified immunity for law enforcement. This is a nakedly partisan and fear-mongering action when we have so many more important issues to address. There is nothing in the Illinois Safety Act that would remove qualified immunity for police officers. Qualified immunity is an issue of federal constitutional law. It cannot be changed by the state of Illinois or any county government. John Sandage and the Justice Committee should be focused on county issues, not representing newly adopted state laws or stoking fear among constituents. I ask you to vote against this resolution. We should be focused on the work of the county, not getting bogged down in non-existent state issues. Thank you, Jill Blair. Next is Sherry Stroll. I have read with great interest the local and national coverage of HB 3653. I attended a webinar last week sponsored by Unity Partnership, a non-for-profit dedicated to positively impacting the relationship between police and civilians, The panel at this webinar included members of the state legislature and members of law enforcement. I also viewed a recording of the Joyce Foundation's webinar on HB 3653 this weekend. Their panel included many who worked on the bill, including a crime survivor expert. One of the myths about this omnibus bill was debunked on both webinars, yet I see that your resolution appears to be spreading the misinformation that HB 3653 ends qualified immunity for law enforcement. Why would the McLean County Board spend time spreading misinformation about this resolution? Surely you have other things you need to focus on. This past summer, our local law enforcement agencies stood shoulder to shoulder with the Bloomington Normal NAACP and committed to the NAACP's 10 shared principles regarding the relationship between law enforcement and the communities and the people they serve. The outcry and spread of misinformation about HB 3653 from law enforcement calls into question their commitment to these principles, and that is disappointing to say the least. Please do not participate in this. If we as a community truly want to be better, this is not the way. Thank you, Sherry Stroll. Next is Kyle. I'm going to not get the last name right, so it's Auer. I am reaching out to you today as a concerned citizen because of a resolution to protect and support qualified immunity. I believe this is going in the wrong direction with police accountability. If qualified immunity is protected, then where will accountability be when officers do not do the right thing? Qualified immunity ensures that they just get a slap on the wrist with no real consequence for doing any criminal-like behavior on or off the job. We can all agree that we want those who commit a crime or an act of violence to be held liable. Then why would passing this be a good idea? I implore you to vote no on this resolution protecting and supporting qualified immunity. Thank you for your time, Kyle. And again, I apologize, but Auer is the last name, Ayer. The next was submitted by Whitney Underwood. As a resident of McLean County District 9, I support the recent Illinois Criminal Justice Reform Bill, as well as additional reforms to ensure that all citizens are equally protected and served by law enforcement. I do not support McLean County's proposed resolution opposing any future laws restricting qualified immunity. Please vote no to this resolution, as it does not represent the wishes of your constituents. In order for all of my neighbors to feel equally protected by our police, we need accountability. We can value and support our police force while also holding them accountable whenever they fail to act in an honorable manner, just like we hold anyone else accountable. Whitney Underwood. Next is from April Blair. I urge the McLean County Board to vote no on passing the proposed resolution to stand against House Bill 3653 and to support qualified immunity for law enforcement. In the court system, it has been demonstrated that the definition of clearly established, end quote, statutory or constitutional rights is so vague and unusual that it is nearly impossible to hold law enforcement accountable for misconduct, no matter how blatant. We must put the rights of citizens first, which includes their right to seek justice, even when the accused is a government official. April Blair. Next is Elizabeth Babin. Vote no on resolution supporting qualified immunity. Ending qualified immunity is a vital step to police reform. Too many police officers are getting away with murder because it isn't possible to hold them personally accountable. Sincerely, Elizabeth Babin. Next is Jenna Kearns. I am writing to ask you to vote no on the resolution supporting qualified immunity. The effect of qualified immunity has long been that law enforcement has not been held accountable for their actions, especially in cases of the use of excessive force. The way qualified immunity has been treated in Illinois courts has the effect of creating an almost limitless doctrine in the sense that it's nearly impossible for the victim of police brutality to meet the ever-expanding test to prove law enforcement violated their constitutional rights. Standing up to make changes to qualified immunity is not mutually exclusive to supporting law enforcement. I think it's narrow-minded and short-sighted to believe that the systematic problems with our society's law enforcement system will change for the better without fundamental change to the system itself. One ripe area is that we as a society review how qualified immunity has created an impenetrable shield, allowing law enforcement to engage in negligent activity without proper checks to hold them accountable to the people they are supposed to be protecting. As a resident of McLean County and a constituent of the McLean County Board, I must ask that you listen to the people you represent and vote no to this resolution. Thank you, Jenna Kearns. Next is Hope Morris. Vote no on resolution supporting qualified immunity. Members of law enforcement need to be held accountable for their actions as much as any other citizen. Transparency and accountability are what builds trust in a community. Many Bloomington citizens do not trust police, and this stems from a lack of transparency and accountability across the nation and in our community. We need you to vote no on this resolution if we are to rebuild trust in our communities. Vote no on resolution supporting qualified immunity. Thank you, Hope Morris. Next is Pete Guther. Please vote no on the resolution in support of McLean County law enforcement and opposing changes to the Illinois Qualified Immunity Act. This resolution is a particularly tone-deaf move at this moment in history and, despite its opening 3 paragraphs, is offensive to the notion of excellence in law enforcement. Ending qualified immunity is not an attack on good police work. I am a huge believer in the police and believe that they all need our support, but supporting qualified immunity drags down the good name of all police by failing to hold accountable those rare individuals who abuse their badge or our trust. If you'd like even more reason to vote no to this resolution, I suggest you watch last night's episode of Last Week Tonight with John Oliver, subject raids, on HBO Max, also available on YouTube, and he provides a link to that, Thank you for your consideration, Pete Guther. Next is Juliet Lind. I am writing to urge you in no uncertain terms to vote no on the resolution in support of McLean County law enforcement and opposing changes to the Illinois Qualified Immunity Act. Ending qualified immunity is a vital step in police reform. We see over and over again how officers are not held accountable for the use of excessive force, and it is high time this change in order to restore trust in law enforcement for all of our communities. Sincerely, Juliet Lane. Next is a Carla Bailey Smith. The proposed resolution in support of McLean County law enforcement and opposing changes to the Illinois Qualified Immunity Act, which seeks to praise our law enforcement officials, also addresses an unnecessary issue of qualified immunity. HB 3653 does not end or even address qualified immunity. The phrase in the resolution states quote, the McLean County Board wishes to express its concern for and objection to any further erosion or reduction of the protections provided by the Illinois Qualified Immunity Act, close quote. It seems that the authors of this proposed resolution do not understand the contents of HB 3653. I would be happy to provide a summary of what the bill does and does not do to anyone who wishes to see the facts. The other part of this resolution, where we praise and uphold our law enforcement, seems to come from a place where law enforcement officials feel attacked or oppressed. When you read and comprehend what was actually passed, what is covered in HB 3653, you will see that Illinois is trying to prevent oppression by law enforcement, and to make sure our officers are properly trained and mentally equipped to do their jobs. The bill seeks to improve public safety and limit unchecked authoritarian behavior by law enforcement. Please vote no on this resolution, if only for the reason that the language of further erosion or reduction on the issue of qualified immunity is factually incorrect. Carla Bailey Smith. Next is from Michelle Sanders. As a resident of McLean County, 10 years and counting, vote no on resolutions supporting qualified immunity. We need to trust our police again, and not being able to hold them accountable for their actions will erode that trust farther. Michelle Sanders. Next is from Sarah Breeden. Regardless of how many chest-pounding whereas statements are made, this resolution is a performative mockery of the very real problem of police brutality. Our county board and law enforcement should be embracing and resolving with meaningful action efforts to reform areas of our criminal justice system that perpetrate systematic racism and abuses of power. Instead, this resolution reeks of irony, such as Gertrude said in Shakespeare's Hamlet, quote, "The lady doth protest too much, methinks," end quote. Sarah Breeden. The next comment is by George Gordon. I urge the McLean County Board Justice Committee to oppose, or at least table, Agenda Item 5A1. There is no qualified immunity provision in the criminal justice reform legislation recently signed into law by Governor Pritzker. Thus, this resolution addresses an item that doesn't exist, and therefore an unwarranted distraction from the real business of the committee and the county. Thank you, George Gordon. Next is from Diane Mather. I wish to make a public comment concerning the proposed resolution for qualified immunity for law enforcement personnel. Law enforcement personnel have a lot of power over the people they engage with. In exercising this power, they already have immunity over reasonable mistakes. We have witnessed this by the decisions made in our courts. Our court system respects their role and grants them the benefit of the doubt. In many high publicity cases, members of law enforcement are not charged even when the evidence to the contrary seems overwhelming. Law enforcement personnel are people who emerge from our general population. Many will be fair and do a good job, and others will act according to their conscious or unconscious prejudices. I have been in local focus groups where young people of color described encounters with our local law enforcement and would definitely qualify as harassment. It has not escaped my attention that many of the people apprehended in the recent Capitol riot were related to law enforcement or the military. Research is revealing that white supremacists have encouraged their people to go into law enforcement. That does not rule out that most police are doing a good job under very difficult and dangerous circumstances. Why is this an issue now? What does granting more power to those who already have power mean for those with less power? Is this immunity really needed in addition to that already available? This resolution has the appearance of being political instead of one that will actually enhance people's civil rights. Instead of focusing our attention on immunity, perhaps the county would be better served viewing emerging successful law enforcement models such as the STAR program in Denver. Justice should be the issue, not immunity. Diane Mather. Next is from Rob Grizzle. Please vote for the resolution protecting our important law enforcement officials and officers so that they can effectively protect the tax-paying citizens. Thank you, Robert Grizzle. Next is from CJ Dyer. Vote yes, please, on the resolution supporting qualified immunity. CJ Dyer. Next is from Brenda Garrett. Please support our law enforcement officers by voting yes to the proposed resolution that opposes law enforcement accountability. This resolution was written in response to House Bill 3653. We need to support our police agencies, not give in to the pressure from individuals and groups that do not have the best interests of our community in mind. Thank you for supporting this resolution that protects and supports our police officers. Brenda Garrett. Next is from Hannah Selmeyer. I urge you to vote no on the resolution supporting qualified immunity in Bloomington Normal. It would cause direct harm to people of color and people in poverty in our community. If this resolution is passed, police officers, like everyone else, should not be allowed a scapegoat when they commit crimes against others. Please urge your fellow council members to vote no as well. Hannah Selmeyer. The next one is from Crystal Dickerson. As a resident of McLean County District 4, I find it ridiculous that the McLean County Board would be considering a blanket opposition to removing qualified immunity from law enforcement. Specifically, section reading, quote, whereas in light of Governor Pritzker's recent signing into law of House Bill 3635, the McLean County Board wishes to express its concern for an objection to any further erosion or reduction of the protections provided by the Illinois Qualified Immunity Act, end quote, as well as the section reading, quote, whereas the McLean County Board strongly opposes such changes and urges Governor to reject any attempt to further limit or constrain protections granted by the Illinois Qualified Immunity Act, end quote. Last time I checked, every member of the county board is elected to represent constituents. This resolution is not something that speaks for me or represents my opinion on qualified immunity. There have been 0 public input sessions on this matter other than talking in secret Facebook groups between board members, the sheriff, and others, as well as an email sent to Republicans on the county board from Sheriff Sandage with the ordinance that he personally wanted enacted. Don't you think that before you create a blanket resolution that supposedly represents all of McLean County, you had better make sure that it's something your constituents actually want? I could go on and on about why we need to end qualified immunity, but I believe that most of my words would fall on ears that choose to selectively listen to conspiracy theories rather than actively listen to the voices of the people in McLean County who they are supposed to represent. However, for those of you who are willing to explore the topic, you can click on this link. Schwartz Joanna C. and Stoughton Seth W. The Unnecessary Protection of Qualified Immunity, Verdict Comments, 26 June 2020. Furthermore, McLean County should never consider a resolution for blanket indemnification. There are already duty to defend and indemnification clauses in the police union contracts that provide safeguards for officers that are acting constitutionally. Police brutality can happen anywhere. McLean County is not immune or specially protected from from officers who make bad choices in the line of duty. I apologize. If something like what happened with Elijah McLean Brianna Taylor, or Sandra Bland happened to someone in our community, do you think the people who live here would want their tax money being paid out in settlements that protect officers who acted unreasonably or unconstitutionally? I have also heard countless times from our local elected Republican officials that matters related to state and federal law need to be handled at the state and federal level and not be decided on locally. While I do not share this same opinion, I do find the hypocrisy quite amusing. I also do not believe that the county board actually has the power to unilaterally grant officers here qualified immunity, especially in the event that the state does decide to abolish qualified immunity. Instead of focusing on this resolution, I would encourage the county board to focus on emergency housing, homelessness, COVID-19, and getting ahead of the schedule for enacting all of the regulations included in HB 3635. The last numbers I saw from January 29th showed that we had 100 inmates pre-trial being held in jail for drug offenses, 40.9% of inmates, 7 being held pre-trial on misdemeanors, and 56 being held for felonies related to property, not people. I think a more efficient use of the Justice Committee's time would be to support the sheriff in decarceration. Thank you, Crystal Dickerson. I apologize. The next comment is by Joyce K. The Justice Committee should not stoke division and fear. This is a good bill for reform and does not touch qualified immunity. Next is from Nicole Boozer. Please vote no on the resolution supporting qualified immunity. Our county board should be embracing efforts to reform the criminal justice system that perpetrate the idea that police can do no wrong and do not deserve to be held accountable when their actions cross the line. We have seen too often that the current system declines to hold so-called bad police officers accountable. McLean County is not immune from officers who make decisions that hurt, maim, or kill innocent citizens. The board should be more focused on protecting the everyday citizen and their rights. Things need to change, and it begins with changing qualified immunity. Again, I urge the board to please vote no on the resolution supporting qualified immunity. Nicole Boozer. Next is Jackie Bayer. I am writing to strongly urge you to vote yes on the resolution in support of McLean County law enforcement and oppose changes to the Illinois Qualified Immunity Act. It is important that we support our police officers and their commitment to serve. HB 3653 will already reduce the safety of the communities in McLean County by limiting what police officers can do and by causing police officers to quit the profession, retire, or move out of state. It is imperative that we provide some semblance of protection for our officers and provide some incentive to serve our communities. I appreciate your consideration and hope that you have the strength to stand up and support the officers who work tirelessly for our communities. Jackie Bayer.
Ms. Norlack, that's 30 minutes.
Okay, thank you.
Thank you, Julie. All right, the next item on the agenda is item 4A1A, request approval of an intergovernmental agreement between the City of Bloomington and the County of McLean regulating the use by the County of McLean of the police shooting range facility of the City of Bloomington. And can I have a motion? Motion by Member Martin. Yeah, motion by Member Went. Sheriff Sandage, would you like to discuss that?
This is just our yearly renewal, allows us to use the City of Bloomington firing range for our range practice and qualifications.
All right, do I have any comments or questions? All right, seeing that, Julie, go ahead, let's go ahead and vote. And the chairman will be voting. I want to say the chairman will be voting on all items on the agenda tonight.
Thank you, sir. Member Went. Member Went?
Yes.
Thank you. Member Schaefer?
Yes.
Yes.
I got it, George. Thank you. Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Chairman Eric.
Yes. The next item. Good to go. There's an echo or something. I don't know. I'm hearing something. The next item on the agenda is item 4A1B, request approval for the Emergency Management Agency to enter into a memorandum of understanding to establish additional vaccination sites, Friends Emergency Management Agency. Can I have a motion? A motion by Member Schaefer, a second by Member Chung. Sheriff Sandage, on yours, isn't it?
This is through our Emergency Management Agency. Should the need arise to open more vaccination sites, we would need a memorandum of understanding with those sites to protect both sides. So that's exactly what it does.
All right, do I have any questions or comments? All right, seeing none, the chairman will vote. Let's go ahead and vote.
Member Wendt,
Yes.
Chairman or Member Schaefer,
Yes.
Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Chairman Erickson.
Yes. We good? Thank you, Julie. The next item on the agenda is item 4A1B, request approval of a resolution of the McLean County Board approving the adoption of the National Incident Management System. And can I have a motion? Motion by Member Smith, second by Member Chung. Sheriff Sandage.
Yes, the National Incident Management System is what all disaster agencies typically use. We've been part of this in the past. Every couple of years, things get added and updated, and we just need to renew our resolution on that.
Any questions or comments? The only question I had was I just wondered if in paragraph 1 it says, since a memorandum refers to, the resolution refers to domestic incidents. I just wondered if paragraph 1 ought to say domestic incidents as opposed to disaster incidents.
That's a very good question.
I mean, anybody know?
I believe it's supposed to be domestic.
Member Martin?
Since I deal with this every day, I believe that the language is, it's a federal agency that has done this language, and you'd have to check the NIMS book, but I think the sheriff's right. I think that's the way it's written, but I could be wrong.
Well, the sheriff said, I thought he said that it should be domestic. I mean, I don't think this is a big issue. I just want to get the language right. I mean, I'm not going to sit here and don't hang us up on this. I mean,
I think the intent was domestic, meaning within the United States and not abroad.
okay, is the county administrator there, should we amend that to say domestic, or is that just how do we address that?
If I may, Chairman Erickson, this was submitted by our emergency management agency, and I would make at least an assumption that they did mean domestic, because the national system does not just deal with, for example, natural disasters. It could mean an incident of a certain kind that required our emergency management agency to respond outside of a tornado or a flood. And so that's why I'm wondering if it meant domestic, because in general, I would have to assume that our emergency management agency would not respond to outside threats on an international level. I hope that makes sense, and I hope the sheriff agrees with my assessment there. If he does not, he should say so.
I agree.
Thank you, sir.
Should we change that then? Is that what we need to do, or just leave it as it is?
If I can make a
Make any
suggestion,
difference to me? I mean, I just want to know.
I would not recommend changing it if this is how the department provided it. If the board would like to wait, we can certainly go back and consult with the department and then bring this to a stand-up or with the approval of executive committee there under your committee, Chairman Erickson.
Well, I don't want to bring it up again. I mean, if we're happy with disaster, let's just keep disaster. I mean, it doesn't make a difference to me. I mean, I just thought it should have said something else, but I can be wrong from time to time. Do we just keep it the way it is? Let's vote. You want to do it that way? I mean, all right, I guess I'm the chairman. I guess that's what we're going to do. We're going to vote the way exactly what it says right there in the document. All right. So Julie, go ahead and call roll call.
Member Went. I can see him talking, but I can't hear him.
What item are we voting? I had to get off and come back on because I was losing everything. What item are we?
We're voting on 4A1C.
The NIMS Incident Management System.
Okay, yeah, all right, yes.
Member Schaefer. Member Chung.
Yes.
Member Smith.
Yeah.
Member Beer.
Yes.
Member Martin.
Yes.
Chairman Erickson.
Yes. Thank you. The next item on the agenda is the monthly statistical report. Sheriff Sandage, do you have any comments about that that you care to make?
Just that currently we have 37 inmates, again, that should be in the Department of Corrections, but are not. The last time we were able to take inmates to Statesville Correctional Center was on February 23rd, and we were finally able to get some female inmates transferred to Logan Correctional Center on February 17th. But like I said, we still have 37 in our custody that should be in the Department of Corrections.
Any questions of the sheriff about the report? Member Chung?
Yes, thank you, Chairman Erickson. Sheriff Sandage, I guess I just have a question because again, I'm new here to this committee. One of the public comments that I had received in my inbox over the past week, and I think it was actually read by Ms. Morlock. They mentioned that there had some, I guess, different sort of statistics, I guess, than what we are provided in our report. So, it said here, I have this email here, 100 inmates pretrial being held in jail for drug offenses, 7 being held pretrial on misdemeanors, 56 being held for felonies related to property. I guess I'm just wondering the history of like what you decide to put in the report, and I guess if there's any reason why you see maybe we should or should not get this other sort of information.
I have no objection to that information being released. We just typically provide the numbers and not the breakdown. But I'd be happy to get you those numbers if you'd like.
Thank you. I guess I don't know if the chairman needs to do that, or we just ask, or I mean, I would be interested in seeing that from month to month. I don't know if that puts a huge amount of extra work on you. I mean, I guess since these numbers are here and we're provided to this person in the email, I guess hopefully it would not be too much extra work for us to get it. But I would be interested in possibly seeing that in your monthly report. Thank you.
And those are things we also look at with Criminal Justice Coordinating Council to make sure that we're using the jail to the best of its ability.
Is that a hard thing to produce, Sheriff Sandage, or just something that we can include, or do you have any thoughts on that?
No, the numbers are out there, but yeah, I'd be happy to provide them.
All right. Why don't we try it this, Member Schaefer, go ahead.
Well, I guess the only thing that I would question is that how valid would those numbers be, because they're just a point in time on that day, so that they're, you know, it's that day that you create that report. And granted, the same thing with the numbers on the jail, numbers in the jail. It's an aggregate number, but it's an average. We also have an average too on that, where I don't think we can get an average on some of those other numbers. It would just be a point in time, and I'm not sure how meaningful that really would be, because it would change. It could change between the time you create the numbers and the time that we actually have our committee meeting. And so, can you maybe address that issue?
That's correct. I mean, any numbers given would just be a snapshot of that moment in time. If you wanted numbers, say, as of the first of the month, this is what we had and what they're in for, I can give you a specific date. But for the whole month, it's like Susan said, it will vary a lot.
Well, why don't we try this? I mean, could you get that report to Member Chung individually, you know,
Sure.
for the next meeting? And then if you want to bring it up, Member Chung, at the next meeting, say this report is the best thing I've ever seen, and I want to make sure it's in the Justice Committee packet every month, and bring it up again. You want to try that? Member Chung, is that okay?
Yes, thank you. And thank you, Sheriff Sandage.
You're welcome.
Thank you. I think that's it. Thank you, Sheriff. Do you have anything else you want to add, Sheriff Sandage?
I do not at this time.
Thank you. Member, I see you got your hand up.
Yes, I'm sorry. I forgot I had another question. I was just wondering about the sort of, I guess I ask this every month, sort of the vaccination and how it's coming along with your staff and your deputies, like the sort of, I guess, numbers and the percentage of how many people are vaccinated right now.
Yeah, we cannot, of course, make our employees get vaccinated. So I don't have those numbers to release.
Any other questions? All right, seeing none. Thank you, Sheriff Sandage.
Thank you.
All right, the next item on the agenda is item. What's wrong with me? 4A, not 4, is that 4B? Yeah, 4B, Kathy Yoder, McLean County Coroner. She's not here tonight. She does have a monthly report. The county administrator advised me today that she would not be here, but the county administrator graciously agreed to answer any questions on her behalf. So if you have any questions for Kathy Yoder, if you want to send them through the county administrator, we'll do that. Any questions?
And then Chairman Erickson, I might say, I'm going to have to consult with Dr. Yoder and get back to the number.
All right, seeing none, we'll move on to the next item then. All right, the next item is item 4C1A. Request approval of an intergovernmental grant agreement between the state of Illinois, Illinois Criminal Justice Information Authority, and the county of McLean, number 219446. And can I have a motion to approve? Member Martin, we have a motion by Member Martin, a second by Member Chung. Is Mr. Rigdon, are you speaking on behalf of the state's attorney tonight? I see Don's on there too. I don't know who's talking.
He certainly can. I don't have video, but I'm here. This is a renewal of a grant that funds victim witness services. We're lucky to have it, and we got it again for the next 12 months. So Brad or I could take any questions on this.
All right, do we have any questions? Any comments? All right, seeing none, the chairman will vote. Go ahead and take roll call, Julie.
Member Went,
Yes.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Chairman Erickson.
Yes. All right, the next item is item 4C2, caseload and forfeiture fund and general reports. State's Attorney Knapp, do you want to address that? Do you have any
I just
comments?
have, we're happy to take any questions. It's a little early in the year to project forward whether we'll be above or below where we're at, especially or where we're traditionally at, especially with the some students gone and others coming back. Happy to take any of them. As you saw, I added in, we've done a rash of murder trials recently, and I gave you a little bit of a historical perspective of how odd that is, or how historically different that is at the Law and Justice Center to have 10 murder trials in 21 months, when traditionally in the 2000s, in the entire decade, they did one a year. So again, happy to take any questions. Brad's available to take any questions as well.
Do any of the members have any questions or comments?
Perfect.
All right, seeing none, thank you, Mr. Knapp, and thank you, Mr. Rigdon, unless you had anything else you wanted to add.
That's it.
Thank you. The next item on the agenda is item 4E. There's no item for action under the circuit. I'm sorry, I skipped one. I'm going back here, and we're going to go and do 4D. Sorry, Mr. Donovan, I went right past that one. All right, the next item on the agenda is item 4D1A. Request approval of an agreement with Swink Motion Pictures, Inc. for public performance licensing. And can I have a motion to approve? I have a motion by Member Smith, a second by Member Went. Mr. Donovan, do you like to address it?
Yes, sir. This is just a ongoing contract or agreement that we have with this motion picture distributor for copyrighted and licensed DVDs for the residents at the detention center.
Thank you. Do any of the members have any questions or comments? All right, seeing none, the chairman will vote. Go ahead and do roll call, Julie.
Member Went,
Yes.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
I'm sorry, Member Martin,
Yes.
Chairman Erickson.
Yes. All right, the next item on the agenda is item 4D2A. It's the report of Court Services Adult and Juvenile Division Statistics. Mr. Donovan, is there anything you want to say about that?
No, nothing to add. Business as usual.
Any questions of the Mr. Donovan? All right, seeing none, thank you.
Thank you.
The next item on the agenda is item 4E. There's no items for action. We do have item 4E2A, statistical reports, and item 4E2B, FTE amendment. Everhart, do you want to address those?
Sure. First of all, my monthly statistical reports are nothing unusual report. Item B would be an amendment to remove a part-time position, a 0.8 FTE to a 1.0 FTE to assist with expungements. Increase the amount of expungement. My office is handling. Yeah, I'm open to questions. Can everybody hear me?
I can hear you, Chuck. George, can you maybe mute your mic? George went.
I'm trying to.
Okay.
I thought George had said something, but I guess not, so.
No, I don't say anything.
All right, thanks.
For some reason, my mic won't mute. I've been having a lot of trouble.
Do you have any other comments, Mr. Everhart, about the other item? Full-time amendment?
I don't.
Okay, that's fine. If you don't, that's fine. All right. I just want to know if you wanted to address it.
Well, I did. I thought I did. You maybe didn't hear, or.
Well, I was looking for something, so if you did, I apologize.
Okay. Does anyone have questions then?
Anybody have any questions? All right, I seeing none. All right, I think we're good.
All right.
Mr. Everhart.
Thank you.
All right, you're going to have to excuse my negligence, but I lost my next page of my agenda, so I don't know what I did with it. I can't find it sitting anywhere here. So if someone could read that next item on the agenda, because I don't have it.
Chairman, this is Camille, and I'd be happy to assist. We are on item F under Public Defender, and there are no items to present for action in that area. There is a caseload report on pages 49 to 51 of your packet, and there is an interim public defender present. Mr. McEldowney, I believe, is here, and I see him in the square. So, Chairman Erickson, you have a representative from the Public Defender's Office to discuss the report.
Okay. Do you have any questions of Mr. McEldowney? Do you have anything you'd like to add, Mr. McEldowney, about the report?
No, I don't think so. It seems like traffic cases are up, but I'm sure that's in the short term, and things will even out over the course of time.
Any questions of the public defender? All right. Seeing none, I guess that's it. I guess we go on to the next item, which I don't have the paper for. I don't know how I got it.
We're a team, Chairman Erickson. Next is item G, which is Ms. Molly Evans. She's the director of the Children's Advocacy Center, and she is here to be with us tonight. Item G1, she has no items to present for action. So item G2 is her monthly statistics and general report. Ms. Evans.
Hello, I have nothing further to add, but I'm happy to answer any questions if you have any.
All right, do we have any questions? All right, seeing none. I guess we'll move. I did find my piece of paper here. So I think we left off. I apologize to the committee. I don't know why. If I got in the stack of paper, I couldn't find it. All right, we're still on 4G, but we just did 4G2, right? Is that where we?
Yes, sir.
All right. Thank you very much. I appreciate it. All right. Next item on the agenda is item 4H1A, request approval of an emergency appropriation ordinance amending the McLean County fiscal year 2020 combined annual appropriation and budget ordinance. And can I have a motion? I have a motion by member Wendt, a second by member Beer. Any comments or questions? That's what happens, Member Bear. If you don't ever raise your hand, I'll just volunteer you to make the second on some of these. So you got volunteered on that one. And being that there's no questions, let's go ahead and have a vote, and the chairman will be voting.
Member Went,
Yes.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Chairman Erickson.
Yes. All right, the next item on the agenda is item 412A, report on employment activities. County Administrator Rodriguez, do you have anything to add there?
I would just be happy to answer any questions of the membership on that report that we submit each month.
Does anybody have any questions or comments? All right, seeing none, thank you.
Thank you, sir.
The next item on the agenda is item 5A1. Request approval of a resolution in support of McLean County law enforcement and opposing changes to the Qualified Immunity Act. As chairman of the Justice Committee, I have decided that I want to withdraw my motion until next month. I have heard from other county board members that have questions about the resolution as presently written. A month will give us time to address those questions more fully and for them to get for other members to get their questions answered. I do want to be clear that I support qualified immunity. I do think the county board should explicitly say so. However, I believe it is prudent at this time to get these questions resolved before we move forward on the resolution. Most of these questions that I have seen revolve around the criminal justice reform bill, and does it actually say anything about qualified immunity? So I'm going to ask the parliamentarian, what do I do next with my motion? I believe I can withdraw my motion.
I'm on my way. Sorry, clicked the wrong button. I thought I was following George Wentz procedure there.
I can withdraw my motion or my resolution, can I?
Right. Assuming no objection, it's fine to withdraw it and remove it. And then it needs to just be rescheduled if that's the decision.
Okay. I don't see anybody raising their hand or saying anything. I do want to say, Chris, if you don't mind, can you give us some stats? Since the question is, what does the criminal justice reform bill actually say? I mean, can you give us some status on the criminal justice reform bill and what it does say about qualified immunity?
I can. First of all, the bill is probably, most everybody knows, if you saw the photograph or video of the governor signing the bill, it's a very large stack. It's 750, 60 some pages. So it's easy for people to think that something is in or is not in there that may or may not be. But I do have, in fact, if you can make me a presenter real quick, Derek, I can put up the page that addresses qualified immunity so you can see exactly what it says.
Yeah, let's.
There you go.
There we go. It's a little hard to see from this angle. There you go.
All right, now this is my first time sharing the screen, so I'm not sure what you're going to see when I hit share. But there, well, we'll cover up my family a little bit there. Sorry. All right, so you can see here this section. Can everybody see that screen? This is House Bill 3653, which is what we're talking about. And this is the section, Article 4, that addresses what they want to do with qualified immunity. And what it says is it creates a task force on constitutional rights and remedies. And the purpose of the task force is to develop and propose policies and procedures to review and reform constitutional rights and remedies, including qualified immunity for peace officers. So that's That's all I need to share, Derek. I don't really want to share anything else. I don't have anything else.
Yeah, as soon as you stop sharing, it'll go back.
Had to find the right button. So in listening to the comments today, there seems to be a disparity of what people think may or may not be affected by this. The way I read that statute is clearly the governor intends to create or has created. Make no mistake, it has been created. And further in the statute, it says that they have 60 days to meet, 60 days from the day that the governor signed the bill to convene. They're required to convene at least 3 times. The statute names the various parties who will have representation on that task force. And, you know, they're convening for the purpose of considering, changes to qualified immunity, among other reforms. So then the question becomes, okay, what does that mean? What does qualified immunity mean? And I'd like to just give you, based on some of the stuff that we've heard today, some of it was close, some of it was pretty far off base. What the United States Supreme Court says about qualified immunity. This is from a case from 2009. And it says, qualified immunity has long operated to protect government officials, not just police officers, from liability for civil damages. It does not protect anyone from criminal charges. One of the comments said something about their committing crimes in their professional or personal lives or something along those lines. It's just absolutely false. It's not true. Qualified immunity protects from civil damages insofar as the conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. And it goes on to say that the purpose of qualified immunity is to balance 2 important interests: the need to hold public officials accountable when they exercise power irresponsibly. One of the comments said that when they act reasonably or unreasonably, they're protected. That's not true. Exercise power irresponsibly and balance with the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. So that's the law as far as qualified immunity. I also think that it's important to recognize the distinction between qualified immunity in federal cases versus what you have in the state case. Qualified immunity, the words qualified immunity just simply mean that there's a qualification to the immunity. It's not absolute immunity. So they're not immune from everything. It's qualified, meaning there are certain things that have to be met in order for the immunity to apply. In the federal cases, that applies to charges in federal court. So a 1983 is an action that 1983 is a federal law that allows people who believe they've been harmed to bring an action when the accused has acted under color of state law. So basically, federal qualified immunity applies to those federal charges. On the state level, we have the Tort Immunity Act, or it's the municipal governmental entities and employees Tort Liability Act. And basically that creates a qualified immunity. It's limited. It also applies in civil cases. And I think that the House bill that was signed is giving that task force the ability to consider qualified immunity. So how that applies and whether or not that will extend to the Tort Immunity Act or to just things that might affect qualified immunity in general, it's unknown at this point. But I think an understanding of that the Illinois Tort Immunity Act only applies to civil cases. It doesn't apply to criminal cases. And it only applies to basically negligence. If they're negligent, qualified immunity will, you and I, if we're negligent and we're not acting in our official capacities, we're responsible for our own negligence. police officers while they're in the act of enforcing a law. If they're negligent, they may be immune under the Qualified Immunity Act. If they're not, if they just happen to be driving down the street and they're not in the process of engaging in or enforcing a law, then qualified immunity may not apply. And the thing that is probably
Sorry, can I make a point of order? I'm just wondering if we're kind of like delving into, like, this is not on the agenda right now, and I'm not the type of person to really want to interrupt a lawyer when they're making sort of making opinions and things like that, but I'm just wondering, I understand that Mr. Erickson maybe wanted a little more information, but this is not really on our agenda, so I'm just not entirely sure what.
Well, actually, it is on your agenda. It's under the other business. Excuse me, I'm sorry. It is
Yes.
on your agenda under other business, but that's up to the chairman if he wants me to continue.
We were discussing, I mean, we were going to discuss this, but then Chairman Erickson pulled it, so I'm not quite sure why this is kind of, to me, it seems like it's delving kind of more into interpretation and opinion. And and if Mr. Erickson wants more of that, and before he sort of revamps this resolution before next month, I'm just wondering if you two can have a discussion together.
Well, I would just say, I'm sorry, Chuck, go ahead. I apologize.
Member Chung, the reason I had asked him to address it was a lot of the questions I got from the members were about qualified immunity and what it was. And I just thought it would be helpful to the members to know what qualified immunity was. And another question I constantly got was, well, Chuck, can you slow this down a little bit and let's give us some time to consider this so we can think about it for a month and digest it. And we want to know, what does the criminal justice reform bill actually say? So my intent of having Christopher speak was just to address some of those questions that I'm just relaying questions that I had got as chairman that constantly were being thrown at me saying, well, we got questions about this, Chuck. We got questions about this. And so I do want him to continue, but how much more longer do you have, Chris?
I don't have much. I would just respond and say one thing, and we can disagree on it, but I'm trying really hard not to give you opinion. I'm reading case law and trying to get, my opinion doesn't matter unless it's on giving you legal advice. It really doesn't matter to anything. What you're asking me for is, what I'm trying to give you is an objective summary of what the law is. And I'd be glad to let you read the cases yourself, invite you to do that. I'm just repeating what the cases say. And the cases clearly say it doesn't apply to criminal activity. It applies to civil activity, civil liability, excuse me. I really don't have anything else, but I would be more than happy to answer any further questions that you might have. And I'll give you facts, I promise. And if they're only opinions, I won't give them to you.
Yeah, one of the reasons I asked him to address it, because I know if it came from me, it would have sounded like opinion, and I wasn't going to sit here and make that statement here tonight. But what I would ask Chris to do, that if he has those cases, that if he has those law review articles or whatever he has, that he makes them available to members of the Justice Committee so he can give them the citations or something to those. So if they would like to review them, they can at their option. Right? Can you do that?
Very, very glad to do that. Very glad.
All right. Does anybody have any questions? All right. Seeing none. Thank you, Member Chung. I do understand what you were saying. Your point was well taken. Thank you. Next item on the agenda is item 6, recommend payment of bills and transfers, if any, to the county board. I have bills here in the amount of $213,318.90. I have a letter dated February 24, 2021 by Michelle Anderson, our county auditor, recommending a payment of those bills. And can I have a motion to pay those bills? I have a motion by Member Martin and a second by Member Smith. Any questions or comments? Hearing none, then call roll, Julie.
Member Wendt,
Yes.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Smith,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Chairman Erickson.
Yes. All right, I think that's all. Looks like that's all. I have my paper here in front of me, and it says the next item on the agenda is adjournment. So we are adjourned until next month. So thank you.